Good morning, everybody. Today we resume the evidence of Ellie, for whom it is good evening, I think. Good evening. Those with mobile devices may use them to report what they hear in the hearing room, but only after 10 minutes have elapsed. They may not use it for recording or photography. Thank you. Ms. Kilroy.
Yes. Good morning, Ellie, or good evening for where you are.
Good evening. Good morning.
You gave oral evidence before this inquiry on Thursday, the 23rd of October. I'm now going to ask you a few more questions about some of the things that you were asked about before. I'm going to start off with the beginning of the sexual relationship with Thompson. It started in early 2001, as you told the inquiry. Can you tell us whether you would have agreed to have a sexual relationship with Thompson if you had known that he was an undercover police officer?
I mean, absolutely not. No, not a chance.
Thank you. Now, you explained that in that relationship you saw Thompson once or twice a week, and you texted and called a lot in between those meetings. Is that right?
Yes, yeah.
What sort of things did you speak about in those calls and emails in between?
So it'd be calls or text messages, and good question. So it would be superficial stuff, how your day went, what have you been up to, planning on when we're next going to meet up, what we're doing next. If he was away and we were emailing, he'd tell me a bit about where he was, what he was doing, and I would reciprocate, just sharing information.
So all of these text messages sharing information, or was there was the character flirty or romantic at all?
Only from the point of view that we were dating. So we were in a relationship and texting each other from that point of view. So yeah, caring, nice, relaxing, romantic, nothing too heavy. We didn't have deep and meaningful conversations over text messages.
So if we were to compare those messages with some of the emails that we're going to be looking at in a moment that you've already seen and the inquiry has seen last week, how do they compare?
From memory, obviously with text messages you don't write as much, but the emails would have been in a similar vein.
Thank you. You've explained to the inquiry that this was your first proper, intense relationship.
Correct.
And your first love.
Correct, yeah.
And also that you could see it going on for a long time.
Yes, I was very comfortable with it. It felt very relaxed and natural. We got on well. I saw it continuing.
So what exactly, can you tell us a bit more about what you thought about the future of the relationship?
I tend not to try and overthink things like that and just see where things progress, but I definitely saw it continuing long term. Whether we ended up taking the next step, say moving in together, that was a possibility.
Did you discuss the future with him?
I don't believe I did, no.
Now, you explained that the relationship carried on like this for about 10 months.
Yes, about that, yeah.
And then one day at the start of 2002, you told the inquiry he turned up for a date and wanted to go on a walk.
Yes, we went round the block, and he explained that he was going to be leaving.
And he told you in that conversation that his ex-partner had decided to move to Los Angeles and take the children with her. He also said that he had started up a small production company with friends.
Yeah, so he said that his ex-partner had a new partner, and he had got a job in San Francisco. And they wanted to move to San Francisco and take the children. And because they're his children, he had to agree. He had already told me prior to that he had started up a production company with a couple of friends. It was very small. He gave me a business card for it at the time, but he said he would be moving to Los Angeles to be nearer his children so he could still see them regularly, and he could work from Los Angeles and be the American branch, as it was.
Was this the first time that you had heard all of this?
I knew about the production company, but it was the first time I'd heard about anything else.
A move like that would have taken time to organise, wouldn't it?
I thought so, yes. When he first told me, he said it was still in the initial stages.
Were you surprised?
I was surprised. It caught me off guard that he was leaving, and I was surprised at how fast it progressed.
Were you surprised that it was the first time that he had told you about it?
The impression I got of it was that he hadn't long known about it.
What did you say to him? Do you remember?
Vaguely. Not really, I'm sorry.
And you said that things moved faster after that, and that one time when you were at his place, you told the inquiry that he said he would have to leave even quicker than he had anticipated.
I imagined that we'd have something like 6 months still while everything was sorted out, but it was way, way quicker than that.
And did he give you a reason as to why it moved so quickly?
I think it was something to do with the fact that some sort of project had come up, and he would then go over and start earlier than he planned.
And how did you feel about it moving so much faster than you had thought?
Not great. I felt like I hadn't really got my head around it, and then it was moving out of control.
What did you say to him?
I'm sorry, I can't remember. Obviously, I wasn't happy about it, but I didn't want to make him feel bad, because it wasn't really something that he could control. And he needed to be with his kids, and he wanted close to his kids, and I understood that. I respected him for that.
You told the inquiry that when he left, he gave you a motorcycle course and said in a card, "See you in the south of France."
Yes, there were two. He gave me one for my birthday, the initial course, and then this was the follow-up course that he gave me. See you in the south of France. I took that as a positive sign that we would maybe keep in touch.
And you said to the inquiry on the last week, and then I got that email. This was after he left. When you said that email, That sounds as if it was significant. Was it significant, that email?
It was significant. It was lovely. It was quick. So it showed that he made an effort, and he said some lovely things in it. So I printed it out and I kept it.
Could we take a look at that email? It's 382892. UCPI, yes. I'm just calling it up on the screen.
Okay.
Three 8289, page 2. So it's UCPI 00000 38289. It's an exhibit to Ellie's statement. Thank you. You've been taken through this and had a look at it on the last occasion, and you'll see in the first paragraph that he is. In fact, I think it must be the second paragraph because I can't see it there. That he makes reference to your arse. It's the third paragraph, I do apologise. It's the third paragraph. He makes reference to your arse. He says, actually, unless I get my ass, that's the local colloquialism for arse in these parts. Oh, and that's just reminded me of yours, but moving swiftly on. Is that an allusion to your body?
Yes. Yeah.
And to your sexual relationship?
Yes. That's how I took it.
And he is telling you, isn't he, that he's thinking about your body in a sexual way?
Yes.
And he goes on later on in that email to give you compliments about your intelligence and your wit. He says you're smarter than you allow yourself to believe. And he also refers to your insecurities and lack of confidence. That's in the later paragraphs in that email. So would you agree that this is an intimate email?
Yes. Yeah.
And then he talks about meeting when you are old and grey. And that's in the last paragraph on this page, and swapping war stories. What does this suggest about how long you will continue to stay in touch?
Yeah, indefinitely.
And he then suggests meeting up on the following page and asks you to consider that. So there he suggests a meeting before you're old and grey.
Yes.
And he asks you in this email not to tell anyone else. doesn't he?
He does, yeah.
So does this look as if he's treating you as a friend or something else?
No, I was delighted when I got that email. It suggested that he still cared quite deeply and didn't want to let the relationship go, and wanted to meet up. And like there was no way I wasn't going to meet up with him.
And is that why you told the inquiry, you printed the email out and kept it because it meant a lot to you?
Yeah, the whole thing. And he said nice, supportive things about me as well, which I appreciated. So yeah, I kept it for all of it, really.
Did that email change the way you felt about the end of the relationship?
Completely, because I thought it was over and the contact was continuing.
What did you think it meant for the future?
Honestly, I didn't know. I didn't. I thought it meant that we would definitely remain in contact, and that we would very least be very caring friends at the bare minimum, and that maybe at some point later on something might happen. Who knows? I didn't put any pressure on it.
When you say something might happen, do you mean something other than friendship?
Yes, yeah,
Something sexual?
yes, a relationship.
How soon after that email did you meet?
I don't know. Whenever he was back. Sorry, I don't know when that would be.
So the email was in the beginning of 2002, about May 2002. Did you meet that same year?
Oh, definitely. It would have been a couple of months max.
Do you remember that meeting, that first meeting after he left?
They've all sort of blurred together a little bit. I'm sorry.
Can you say, despite them blurring together, what that meeting might have been like?
I mean, it would have been like a date.
What does that mean from your point of view?
It would have been the two of us. We would have gone out, maybe dinner, maybe drinks, intimate conversation. Basically, whenever we met up, it was like we'd picked up where we left off.
And where you left off was a sexual relationship?
Sorry, yes, but we didn't sleep together again until later on.
But was there touching?
Touching, hand holding, kissing at the end, and just what I would consider a normal couple going on a date.
So flirting, was there flirting?
In my awkward way, yeah, there must have been.
Do you remember how you parted on that occasion or on most occasions? I mean, you said you kissed at the end.
He would walk me to the train station, wait until my train was coming, we'd have a kiss goodbye, and then I would go to the platform and catch a train.
Did you say anything about keeping in touch?
We must have done, but I can't remember specifics.
Now, in your statement, you said of picking up where you left off, you said this, and this is paragraph 5.2 of your statement at 38206, UCPI 38206. our relationship as it was had come to an end, but some other kind of relationship picked up in its place that was much more than a friendship, as it was intimate, loving, and romantic in nature, and there was always sexual attraction and intimacy in our interactions, whether in person, on the phone, or in correspondence. Every time we met, it was like being on a date. Every time we parted in person, we kissed like a couple. Is that the character of the relationship that continued?
Yes, it was. Obviously, it could never, because of geography, it can never be anything more. So I believed.
But that was, in your mind, the only thing stopping it being a full sexual relationship.
Yes.
And you said in your statement, and also to this inquiry on the last occasion, that you remained in regular contact, emailing every couple of months, and that you met once a year or twice every 18 months before you moved to Australia.
I believe so, yes.
So would that mean meeting perhaps 3 or 4 times in total before 2005?
Sounds about right.
You now know that Thompson was in the United Kingdom, not in the United States, and that he was a working police officer.
Yes.
So he was, in fact, lying now, in addition, about where he was.
Completely.
He was pretending to be abroad.
Yeah.
And inventing stories about what he was doing.
He was.
How do you feel about that?
Like a bit of an idiot, really. Although I say like a bit of an idiot because I was deceived, but I would never, in my wildest dreams, have thought that it was all a lie. That would never have occurred to me.
You told the inquiry that after 2005 you moved to Australia. So now you genuinely were in 2 different continents.
Yes, yeah.
But this did not stop him from emailing you, calling you, and meeting you.
It was the same.
And you have we've looked at some of the emails, and you've said to the inquiry that they were flirty, caring, and fun.
Yes. Yeah.
And we've also looked at a call log suggesting hundreds of calls over this period. Can you remember what those calls were like?
I don't know if they were calls or texts or a combination of both. I know there must have been a time when we were in Australia where we called because it was the only way we had contact with anyone in the UK. But I can't really remember enough about what they were like. I'm sorry.
Can you remember anything about what they were like?
I mean, they would. Again, like whenever we met up, it just carried on. We just picked up where we left off. So they would have been caring, easy to talk to, nice, romantic, all of those things.
How many times do you think that you met him between 2005 and 2018?
It would have been whenever I went back to the UK, which was approximately every 18. I tried to get back every 18 months, and sometimes it was every 2 years. So I don't know, six times.
Thank you.
I'd guess. Very bad maths guess.
You were taken to some of the emails that you found from Thompson when you were in Australia, and I want to just go back to some of those emails. This, again, is an exhibit to your statement. It's at 38281, UCPI 38281, page 4. It's an email from the 14th of July 2011. The title is R, and you told the inquiry that that meant sexual frustration.
Yes.
Is that right?
Yeah.
And the email begins with a series of allusions, and you were taken to this last time, to the very strong sexual attraction he still has for you.
Yeah.
That's right, isn't it?
Yeah, sorry, yes.
And the email begins with a series with those allusions, and he also talks expressly about feeling frustrated and refers to a trip on the bike. Was this a so in the first paragraph, at the end of that paragraph, I was perfectly happy to bin that idea even while on a motorbike.
Okay, yeah, okay.
Was he referring to something that you described in your witness statement, and you also described to this inquiry? You were out in an isolated and public spot, and you went further, you said, than the usual couple's kiss that you'd been having until then. You said it got heated.
Yeah, so I don't know if that was that time, but it may have been. But I was on the back of the motorbike, obviously, and he was riding it. So it might be that time. Yeah, we pulled over and we went for a bit of a walk, and got a bit heated.
So would that have been in about 2011?
I don't know, I'm sorry.
And is it right to say that there was a lot of sexual touching that wasn't kissing on that occasion?
Yes.
In this email, is he making reference to that encounter?
I don't know. I don't know if that's because it wasn't. We went on a motorbike a few times, so I don't know if it was that encounter or a different time.
Well, he says in that paragraph, I had a truly wonderful time. Even seeing you so briefly brought it all back. As for the attraction I so obviously still feel for you, suffice to say I've never felt as frustrated as I did, knowing you were in a hotel near Heathrow without a chaperone while I was stuck in Scotland. He seems to be referring to a particular level of sexual frustration.
Yes, he does.
And then later on in that email, in the third paragraph, he compares you to a mole. Lesson learned, get a mole. This is at the end of that paragraph. It's the second big paragraph. Put mole on pillion, give mole responsibility for keeping an eye on the tyre she's on top of. Is that a reference to you?
Yes, it is, yeah.
And throughout the email, he keeps saying, and we see this in the last paragraph on that page, moving swiftly on. I've just thought of something, moving swiftly on. And he suggests fantasizing about you in a uniform on the following page, and says he might say something shocking. This is on the following page. Are these sexual references?
Yes, they are. flirty, sexual.
And this email is in 2011, which is 9 years after he left the SDS and claimed to have left the United Kingdom.
All of the emails were very similar to this.
Was this email more sexual than emails which had preceded it?
I don't think so, not particularly.
So all of your emails after Thompson left the United Kingdom, you haven't kept all of them, but all of them were of this character.
This are very similar, yes.
You were taken to another email in September 2011, UCPI 38281, page 7, so it's the same exhibit, page 7. And again here he is referring to the ARG condition, which is sexual frustration. And he suggests that photos with lingerie will help him with it. He blames you for leaving him sexually frustrated, being in Heathrow while he was in Scotland. This is October 2011, so it's the previous email, September 2011, maybe page 6, if that's page 7. Thank you. This is the right email. So he talks about the ARG condition. He blames you. He says the aforementioned ARG condition, this is in the 3rd paragraph, you left me in by being at Heathrow when I was in Scotland. So he suggests that you have left him sexually frustrated. Is that right?
Yes, that's correct.
And he says in the last paragraph that he is drivelling. Is that a reference as well to sexual frustration?
More like he's just drivelling on in the same vein. And so he was going to sign off the email.
He then says focus falling apart are in fact. So that is a reference to sexual frustration as well, is it?
Yes, it is. Yeah.
So when he talks about you helping him with the ARG condition, what did you understand that to mean?
Sleeping together.
Is having sex on the agenda then in this email?
It was... Yes, it was on the agenda. Yeah.
And then on the following page, page 7, this is page 7, the October 2011 email. So that's a month later. Was that frequency of emails normal in this period?
Actually, that was probably a bit closer together. I was normally the one that was terrible at responding. So no, that was probably, if it's like 3 in 3 months, that was a lot closer together than normal.
Now this email also has sexual allusions, multiple sexual allusions in it. You've been taken to some of these. And there seems to have been here a suggestion of a November meeting. You can see that over the page. Sorry, it's on that page. I apologise, halfway through. It's the 3rd paragraph. That's my excuse for the slightly slow reply. I anticipate going back very shortly to a job in Asia, so I'm afraid November won't work. Presumably that is a reference to something you have suggested, is that right?
So I may have suggested that I would be going over in November if he was around.
And he then says, "This is a nuisance as I find myself very much suffering from R all the time with only one cure possible. And that cure seems to have positioned herself half a world away." Is that a reference to having sex?
Yeah, that's how I interpreted it, yes.
And he then says, at the end of that paragraph, "Come the long still watches of the night, but moving swiftly on." This reference to moving swiftly on, which appears multiple times in the emails, in the email correspondence, what is that? How did you understand that?
Changing the subject
From what?
from the sexual, from that sort of sexual flirty stuff to kind of trying to not talk about that and move on to another topic.
And then he says at the end of that paragraph, at the end of that page, "Let me know about any dates for holidays." And he also talks in the fourth paragraph, "I don't recall you have a lot of trouble with being bendy enough. In fact, damn it, I've moved swiftly back again." So is that a reference to your sexual relationship?
Yes, it was.
So this is an email full of references to your sexual relationship.
Yes, yeah.
Turning to the next page, he ends the email with "love, which he says in brackets is undiluted by baser desires." Again, is that a reference to wanting to have sex?
Yes, that's how I see it, yeah.
And he makes a request for photos with lingerie.
Yeah, he does.
Standing back and looking at this email as a whole, can you remember how it made you feel?
No, sorry, not at the time. I mean, it stopped me moving on because there was still that connection there, and there was still that. It was still like a very strong reminder of the relationship and the sexual relationship that we had, and it was still suggesting that that could continue in some form or another.
The next email, February 2012, 38281, page 9. So this is in the same exhibit. That email is also full of similar language and references. There are references to lingerie-based photographs, for which I eagerly await, he says, in the second paragraph. He says, "I had intended this email should not descend into a tirade of sexual longing, but I'm not sure how that's going to play out as it's only paragraph 2. He talks about nurses' uniforms in the last section. "No, hang on, nurses' uniforms popping into the head." He talks about reflections on your bum, a delightfully buoyant bum, and then says that he is only able to descend into jealousy or lust. That's on the following page. Again, this is a highly sexualized email, isn't it? The buoyant bum is in the last page, last section of the following page. And he talks about jealousy and lust at the end of that page. And then in April 2012, so that's on pages 12 and 13 of this exhibit, similarly, he begins with reference to thinking of you as being laid up, and that you were taken to this on the last occasion. And this goes on and on throughout these emails, doesn't it? These references. There's one in June 2012, which is at page 15 of this exhibit, again with reference to lingerie photos. Now, you told the inquiry, having been through all of these emails, that it became more likely that you would end up sleeping together throughout this period. Can you explain that? Why did it become more likely?
He was obviously saying that he was, well, to me, I interpreted it as he was saying he was keen for a sexual interaction when I was back in the UK. And I didn't object to that. I was keen as well. So I thought, well, that's pretty much a given. If we're both quite interested in doing that, it's probably going to happen.
So this was something, was it that came from the emails or from other communications?
It's mainly just the emails, and then whenever we met up, but it did seem to build. And I remember saying to Wendy, you know, I think we're probably going to sleep together when I go back.
Is there a date that you can identify for when it started to build, or?
No, the emails were quite similar the whole time. They've obviously just got maybe a bit more intense those years sort of leading up to 2015, but there was always quite a similar thread to them all from memory.
Now, one of the things that you can see from the emails is that you met in 2013. This is at page 20 of the exhibit. You met in 2013. There's a reference to a trip to the United Kingdom from the 15th of July to the 17th of August. Again, he's asking for lingerie photos in this email. Do you remember that particular meeting?
Not particularly, unless this was the Box Hill meeting.
In your statement, you do refer to the Box Hill meeting being seen intimately kissing in a public spot.
Yeah, we were sitting on the hill, and I was in front of him, and he had his arms around me, and I sort of leant back, and we had a kiss. And then there were these two men that walked past, and they looked over at us, quite clearly at us, and laughed. And I thought it was odd. And I mentioned it at the time. I was like, oh, did they see us or something? And he said, oh, it must have done. In hindsight, I think they knew him.
So you didn't have sex on that occasion?
No.
Did that meeting play any part in the build-up that you described just now?
It would have done, because I think the last couple of meetups, there was a bit more than just a kiss and a handhold. So yes, it would have just been sort of the next step.
At page 21 of this document is an email from June 2014. So this would have post-dated that meeting in Box Hill, if it was in 2013, that meeting. And he refers to your bare, naked arse. in the first paragraph and to just reaching out and grabbing it. He says, well, you get the idea, more sordid if I'm honest. And he again asks for naked photos. He talks about thinking of you hanging around his office naked. And on the following page, he talks about not getting distracted by mischief. So this goes on in that highly sexual vein. Is this part of what led to you sleeping together in 2015?
Part of it, yes.
What else led to that? You told the inquiry that you did, in the end, in 2015, sleep together.
We did, yeah. Because I would always sort of have a hotel near the airport prior to the flight. And so when I was over in the UK, we'd arrange to meet up. He would arrange to come to the hotel.
So these emails, which increased, the emails you said were the same sort of intensity, but he had been indicating he wanted to have sex. What made it finally happen in 2015?
I don't know. I thought at the time maybe just circumstance. I didn't think, at the time, I didn't think there was anything more to it than that. I mean, I know now that that's when he'd come forward to the inquiry, but I'm not sure. I don't know. Like, I know he was in a relationship. I don't know. Maybe if his relationship had come to an end, or I'm guessing. I'm not sure. I'm sorry.
Did the initiative come from him?
Yes. But I didn't. Yes, it did.
Just standing back from all of this, getting to where you were in 2015, you have consistently told the inquiry that the relationship was not platonic.
Yeah.
It wasn't a friendship.
I mean, the only way you would call it platonic was because of the distance, because of how far apart we were. But even in every other way, it was more than that.
And when you say more than that, do you mean sexual?
Yeah, like you wouldn't talk to your friend like that.
And looking at these emails and listening to you talking about the meetings, thinking about what you've said, did all your meetings, calls and emails have this sexual element to them?
Yes.
So apart from the separation, which meant you couldn't have sex regularly, would it be right to call this a sexual relationship?
It was an intimate relationship and a romantic relationship, but there was no sex apart from that one time in 2015.
Was there sexual touching on other occasions?
Yes, there was.
After you had sex in 2015, you said that the same type of relationship continued with emails and calls after that until you discovered that he was a UCO. Is
Yes,
that right?
just carried on as before.
Did you meet him again?
No.
And then he told you that he was a UCO and in 2018, an undercover
Yes.
officer. You said that that phone call, which you described on the last occasion, was about half an hour.
Yes.
Can you describe what you spoke about for half an hour?
He told me pretty early on in the call. He sort of blurted it out quite early. He explained that there was an inquiry, that someone might be in touch. He asked me if I still had my old email address. He told me that he couldn't tell me a lot of information. He said he was willing to talk about it and tell me what he could. He said that they will probably tell me his real name, but his first name was James. I can't remember much more, I'm afraid.
Did he say that he had done something wrong?
No, he didn't. He said things were different today than they were back then, but he definitely did not think he'd done anything wrong.
Did he
No,
apologise to you?
There's no apology or anything. Sorry.
I was just going to ask if he apologised, but you've said that he didn't.
No, definitely not. No.
Did he indicate that it was a significant thing that he had deceived you?
No, he didn't. No, he didn't.
Did he use the words deceit or lying?
No, and I thought throughout that conversation that the relationship had still been real, and the other thing, maybe his job was fake, but his friendship with Wendy, his friendship with the L guys, and his relationship with me and his relationship with Sarah, I assumed that they were legitimate and they were honest.
Why did you assume that? What did he say to make you assume that?
He said at one point, my private life is my private life. I don't know, I'm sorry. That whole conversation and a week after it, much as I hate to say it, was like a bit of a blur, like a bit of a dream. So I don't know.
Did he make light of what had happened?
No, I mean, he said you might get a visit from a sweaty Englishman in a raincoat talking to you about the inquiry. I think from that point of view it could be seen as, I don't know if that was light-hearted or resentful, to be honest.
He said that you, Ellie, might get a visit from a sweaty man.
Yeah.
Did that sound threatening to you, or did it sound... What do you think he was trying to do?
It was a little disturbing, that the thought that some random government official would rock up at my door. But that it never happened. I did wonder if I did wait for a few weeks afterwards. I kept on expecting someone to turn up.
He asked you told the inquiry not to tell Wendy because he said she would be angry.
Yes. And I took that again to mean that he was worried that their friendship would be compromised.
Did he not think you would be angry?
I think because when he first said it, it was a bit of a shock, and I laughed, which I like to do in inappropriate times. But I think that caught him off guard, and I said, like, I always knew there was something off. And then, yeah, so one of the other things is I said that they did suspect, that the animal rights guys did suspect that he was not completely who he said he was.
Did they suspect he was an undercover officer?
When he first started out, they said he was textbook, and they said it was really obvious. As time went on, I think they decided that he couldn't be. He was just a little eccentric.
Did you consider seriously not telling Wendy, or?
No, I was going to have to tell Wendy.
In your statement, you say you took some time before you did tell her. How long did it take?
I didn't know what to do. I got off the phone, and I didn't know what to do. I didn't know what to think. I didn't know what to make of it. So I didn't want to make any rash decisions. So I went and had a shower, and then went to bed and just lay there, and decided that I wasn't going to do anything at all for about 24 hours and see if I had a new perspective on it in the morning. Then I told her the next day.
Did you feel that you needed to do what he asked you to do?
I felt that I didn't want to betray him, because I still thought it was genuine, and I didn't want to get him in trouble, and I didn't want to make things hard for him.
Why did you feel that, given what he told you about what he'd done?
I still didn't fully accept that it was about us. I know that sounds weird, especially after he told me, but I still didn't, like, it would make no sense that he would spy on Hunt's apps. That was just, there was no reason for it. And I just didn't accept it. I really didn't accept it.
And how do you feel now about your desire not to betray him?
Yeah, I think it was a process getting over that, but I'm annoyed at myself. I did the right thing telling Wendy, and I'm glad I did. And then the more I looked into it, the more I realised that absolutely every aspect of it was a complete lie.
You told the inquiry about the time he contacted you again, and you said you felt sick.
Oh, yeah, I was at work, and I just got that text out of the blue and just thought, oh, God, that's awful.
Why did you feel sick?
Because he knew, and he was contacting. I hadn't expected him to contact me, and then I had this. It was quite confronting, and just there's a whole range of emotions that go on that you'd like. I was still at that point, I think, feeling a bit, feeling a certain aspect of guilt, I suppose, although that wasn't logical, and I knew it wasn't logical. but I still felt I was quite intimidated by the text. There was no reason, there was nothing intimidating in it, but I felt quite intimidated by it.
Why did you feel intimidated?
Because he knew, and I didn't know where that put me.
What do you think he was trying to achieve by telling you that he knew?
I don't know. I can't speculate.
I want to come finally to the impact on you. You were asked some questions about it, and you said you hated talking about it.
Yeah, I do hate, yes. For a few months after, I just went down rabbit holes. Like, I can't explain the need to know where you need to find out. One of the things I looked at is what kind of personality would be an undercover officer, and from what I read, it's quite similar to con artists, and they tend to have this sort of personality triad, which means they're able to lie, they don't feel guilt lying, and they don't feel empathy. So they tend to have quite strong traits of psychopathy, narcissism, Machiavellianism, all of that kind of stuff. And the problem with that is people like that do not like being confronted, do not like being called out on their behaviour, and it's very common for them to want revenge. So that's something I'm very aware of, and he knows where I live.
So are you saying that you're frightened?
I'm sure that there's going to be repercussions. I just don't know when, and I don't know where they're going to come from.
And is that why you told the inquiry that you couldn't trust people?
Yes, like I'm sure that he's keeping an eye. That's their job, was to keep an eye and gather intel. And they did that quite freely when it was for other people. The thought that they wouldn't do that for themselves is just illogical. He would have kept tabs. He would have spied for sure.
And is that why you check your car boot?
I have to check my car boot and my back seat before I get in the car. Otherwise, I can't. I'm going to get upset again. I'm so sorry. Sorry.
Are there any other ways in which you have had to change your life as a result of this?
I think I've just closed off from people. I have checked the house for bugs. I don't know what I'm looking for. I haven't gone as far as knocking holes in my walls, but I did take my fan apart and check. There was nothing in that. Round about when I came forward to the inquiry, when he texted me, there was a period of time. I'm in a dead end street, and there would be an SUV would sort of pull into the street and then pull into my driveway and then sit there for a few minutes and then leave. And I saw that about 3 or 4 times. So I don't know if that happened when I wasn't there as well. But your mind just goes straight back to that. Like, maybe that's related, maybe it's an intimidation tactic. Maybe that's what he's doing. I would take different routes to work, not keep my phone on me. God's sake. I'm so sorry.
And how do you see the future, Ellie, in the light of what's happened to you?
Much the same, really.
Forgive me a moment. Do you want me to pause for a while?
No, I'm sorry. I'll get my life together in a second. I'm so sorry.
No need at all to apologise. I appreciate that this is not easy for you. But if you would like to continue to finish, I'm more than happy to do so, or to rise for a bit if you want to.
No, this is fine. I'm sorry. This is good.
So you were just saying more of the same.
More of the same, yeah. I don't really trust people. So I'm a little closed off.
Is there anything else that you'd like to say before you finish your evidence today?
No, I think that's enough. Thank you.
Thank you very much, Ellie.
Thanks.
I don't have any other questions.
Thank you. Ellie, I apologise earlier when looking at you and speaking to you as I thought, but I now know that I have to look at the camera behind.
It's completely fine.
I hope it looks to you as if I'm looking at you.
It did, yeah, it did.
Thank you very much for giving evidence to the inquiry. To speak of these events over many years now and the effect that they have had upon you is, I know, not at all straightforward for you. I'm very grateful to you for the evidence that you've given. It brings matters to life in a way that the written page never can. Thank you very much indeed.
I appreciate the opportunity, thank you.
I will now rise for just under half an hour. There is to be a procedural hearing beginning at 11:30. Mr. Khan, this is your application.
Good morning, sir. Finally in person, so good to be here in person.
Yes, absolutely. I couldn't agree more. The nearer we get to old-fashioned procedures, the better. Having said that, I've just realised I've left my pen behind. Now I've found it. Got it.
So I've set out in writing my
Yes.
submission, and of course, if there are matters that you seek clarification, I'm more than happy to do that. But in the limited time that we have, I thought it's best that I set out our submissions.
Yes, you have, and done so very fully, and I've read them and understand them.
Thank you. I add a bit here, and so that you're aware, this application made on behalf of those who are most directly affected by your decision. Baroness Doreen Lawrence, who's, I think, on the video link, Mr. Grover, the monitoring group, as well as Mr. Michael Mansfield, King's Counsel. And the application, sir, so that it's clear to everybody, is that you reconsider your decision and that HN81 gives oral evidence this inquiry. I don't go to your ruling, but in your ruling you base your decision on the report of Dr. Tirani, together with responses received from HN81's lawyers. And so with respect, we submit that the process by which you came to that decision is fundamentally flawed. We start, as we said in the opening statement, that the application by HN81 should be viewed with caution and suspicion because, again, as we said in the opening statement, there appears to be a growing pattern of officers raising mental health as a reason that they should not attend the inquiry to give oral evidence, and I'll come to the detail of that. We have, with the limited information we have available, subjected HN81's application to close scrutiny. And in so doing, we submit that your decision was wrong, and we set out why. And it should be reconsidered with respect. And whilst ultimately it is within your discretion as to whether HN81 should be required to give evidence, that decision, we say, must be based by consideration of all the relevant factors, and not based, as it appears to be, in relation to the ruling, solely on the medical evidence advanced on behalf of HN81. And the relevant factors we say that you ought to have considered and should consider in reconsidering your decision, they would, we say, drive you to a different conclusion. And the first factor, which is not set out and we're not considering the ruling, is the importance of the evidence. And I suspect that this is accepted by all parties to the inquiry.
It is certainly accepted by me.
And therefore this, we say, the more important the evidence, the greater the weight to be given to calling the witness. And that is necessary in the balancing exercise in terms of your decision.
Again, I wholeheartedly agree, and it was my sincere hope when I made the order restricting publication of his real name that that would occur.
Thank you, sir. The importance of his evidence is not only that he was involved in the undercover spying, but it went to the heart of the institution which was responsible for his conduct, sanctioned and rewarded by the then Commissioner of the Metropolitan Police. And this goes to the very heart of whether him and others were rogue officers or whether this was an institutional problem.
Whether or not the information that he provided about the Stephen Lawrence campaign was sought or sanctioned at higher levels than the SDS is a matter that will be explored in evidence with those who made the decisions and have produced documents about it.
Thank you, sir. But the point is this, and that's the second factor that we come to, sir, is his evidence is disputed. And when you come to consider his evidence, there needs to be a resolution of that disputed evidence. It's critical to get into the truth. And indeed, sir, you may or may not recall that the very reason Theresa May, then Home Secretary, set up the inquiry in the first place was because Mark Ellison, King's Counsel, could not, as he put it, make definitive findings concerning HN43's claims. And he therefore suggested that the proper course of action was that it should be dealt with in the course of a public inquiry. he had a review on paper in terms of the various accounts given, and he could not reach a conclusion. And I recall, without giving evidence, that when Baroness Lawrence and I met the Home Secretary at the time, that one of the key features that influenced the Home Secretary was whether it was necessary for evidence to be given and tested in order to come to conclusions. But that is not something that I'm putting forward. That was part of the Ellison review and the conclusion that he came to. So in order to determine what the truth was, as between the accounts given, the necessity to call this witness is vital in the course of getting to the truth. That was the genesis and foundation of the inquiry. So any material intended to interfere with that, i.e. the calling of evidence in order to test it, we say, in the judicial exercise that you have to go through, must be given little weight indeed. And more so, as is noted by those representing HN43, HN81 has called him a liar, casts other aspersions on what he says. And it may be that whilst our court participants ask that you favour HN43's account over HN81's, and on the face of it, we might welcome the fact that he's not giving evidence, so that you can come to any conclusion that you do based upon that fact, that there would be no challenge to his evidence. There's a second factor in relation to the importance of him being called to give oral evidence. And again, it goes back to why the inquiry was set up in the first place. And Baroness Lawrence has waited over 10 years for precisely this process, namely that there is a resolution of the central disputes, but more importantly, what is being stated by the House of Lords Statutory Inquiries Committee report, published in September 24, that public inquiries should provide catharsis to victims. And Baroness Lawrence, in her opening note delivered by me, says that she wants to confront, as she did officers at the Macpherson inquiry, those officers who she says did her wrong. It was cathartic then, and it will be cathartic now. The cathartic element of a public inquiry should not be underestimated. And so when the perpetrators of the wrongdoing escape such public scrutiny, core participants feel cheated, undergo further distress, and are unable to experience disclosure. And so I had the opportunity of meeting Ms. Sukdev-Reel after many years. And she is incredibly distressed by the fact that officers who are alleged to have done wrong do not face up to those consequences, do not come into public and be exposed to public scrutiny. The third factor that we submit you should have taken into account relates to HN81's engagement so far with the inquiry. Our clients note with deep concern and some incredulity that HN81 was able to participate in the inquiry and submit a witness statement consisting of 77 pages in 2023, but then a couple of years later say that in effect he cannot give oral evidence. So we don't have the underlying evidence material. We have no means of assessing why this was the case, but certainly our clients feel it inconceivable that someone who was suffering from post-traumatic stress disorder was able to engage in the way that HN81 did in 23, but then a couple of years later find himself unable to meaningfully engage with the inquiry. And so I think Ms. Kirsten-Heaven will address you in relation to whether this is the true basis of him seeking not to give evidence, given what his lawyer said in opening, that he would not be believed and conclusions have already been reached, but I let her address that. It's this later assertion about whether he is unable to meaningfully engage which brings us to the fourth factor, and it's the nature of the medical evidence. And whilst, again, I repeat, we don't have the underlying material, we have done our own inquiries, made our own inquiries. And as we understand it, Dr. Noreen Tarani is a chartered occupational health counselling and coaching psychologist. And undoubtedly she has expertise in trauma, bullying and organisational rehabilitation. She has, for example, a PhD in trauma from the University of Nottingham. And she's the author of Workplace Bullying, and publication in 2004. Her practice emphasised psychological screening and trauma support for organisations, including police responder wellbeing post the Grenfell fire. We've gone on her website and it describes routine production of full psychological assessment reports for organisations across industries, but they focus on occupational health, trauma support and bullying harassment cases. And it includes clinical opinions for workplace reintegration, often used in employment disputes, but not in legal or evidential contexts. Her career began in occupational health at the post office, evolving into trauma support for emergency services. So nowhere in her credentials or publications does she demonstrate forensic specialism in witness competency or reliability assessments. And a search of cases in which she has given an opinion is limited to one employment tribunal when she was the Surrey Police Force psychologist, where she provided occupational health reports assessing PTSD risks in policing roles. And so with respect to her, whilst her credentials qualify her as an expert witness, her expertise and reports are designed for evidential use in occupational health matters. And so you may not recall this, much time has passed, but you expressed your own reservation about her opinion in the interim report in relation to HN 155's application not to give oral evidence, suggesting that she was reporting out with her expertise in relation to the reliability of HN 155. And so our primary submission is that she lacks the necessary expertise to report on matters relating to the giving of evidence in these proceedings, on which you have solely based your ruling. This is what you said, paragraph 2 of the ruling. In her opinion, Dr. Tarani's opinion, there was an 80 to 90% chance that he, HN81, would be unable meaningfully to engage with the inquiry. Alternatively, his condition is such that the giving of oral evidence would risk a significant impact upon his behaviour and well-being. There were, in her opinion, no arrangements which could be put in place which would make his appearance at a hearing safe. Again, I repeat, while Dr. Tarani clearly has expertise in trauma, on the face of it, we can find no evidence that supports the assertion that the opinion upon which you have relied on is within Dr. Tarani's area of expertise. Of course, if we're wrong about that, and if you and the inquiry and the designated lawyers provide us with material that suggests something to the contrary, we'd welcome sight of it, and we will then engage meaningfully with these arguments, but we don't have it. We rely on the material that we've been able to uncover. So those who practice in the criminal courts are aware that much has changed over the years in the ability of witnesses. Some say it's gone too far, in certainly defence lawyers, especially regarding vulnerable witnesses to give oral evidence in court. And you'll be familiar with the Advocate's Gateway, Toolkit, Special Measures, Ground Rules hearings, and the use of intermediaries. They're all designed to assist vulnerable witnesses in giving evidence in court. And if these measures were not in place, there really would be, and I say this with all, in all honesty, that there'd be no criminal trials and convictions. Colleagues and I have extensive experience of how the system works, with highly traumatized individuals and children giving evidence about their undoubtedly horrific and painful experience. I've spent many a day cross-examining those witnesses or questioning them. I give one example. I was involved in the case of an autistic defendant who had brain damage which caused him difficulty in speaking and understanding, such that he had to use a whiteboard to express himself in giving evidence. He did so for 2 days. He had an intermediary. He had rest breaks which were ordered by the judge almost every 40 minutes. All questions were prepared in advance and checked by the intermediary, and despite these obvious difficulties, there was no question but that he would give oral evidence. The only question was what support was needed for him to do so. And so these adaptations were required, we say, to be explored and should be explored in what happens in these cases with the ground rules hearing for HN81. Discussions then take place as to which of these measures, all of these or more, would be appropriate. And it's only when HN81 actually gives evidence, at that point we say, with all the support that can be given to him in terms of questioning, in terms of breaks and the like, you then, sir, having seen him give evidence, as happened in the case that I was involved in, one can then decide whether he can meaningfully engage with the inquiry. Up until then, I say this, and it may be that the word is not appropriate, but it's almost akin to speculation, that we're anticipating what he's not able to do. We haven't yet explored what support can be given to him in order to give that evidence. It seems to us that in the absence of the underlying material, that Dr. Tehrani has no expertise in such matters. On the face of the ruling, it appears that the issue of what possible steps might be taken to permit him to give oral evidence, for example, as it says in the ruling, by doing so privately, was explored only with H&81's lawyers and not Dr. Tehrani herself. That's what it appears on the face of the ruling. We may be corrected. And despite all the various measures available to a vulnerable witness to give oral evidence, the assertion by Dr. Tehrani, as reported in the ruling, is that there were, in her opinion, no arrangements which could be put in place which would make H&81's appearance at a hearing safe. And that's quite extraordinary, we say, given the nature of vulnerable witnesses in courts on a daily basis. Given what is said in paragraph 3, it does not appear that Dr. Tehrani specifically addressed the measures available. She could and should have reported on each of the measures that could assist, and that is the sort of reports that we get in criminal cases when there is a vulnerable witness and indeed a vulnerable defendant. They address all of the matters that are available to a particular witness and explain how they can or cannot assist. It seems that the apparent rejection or failure by Dr. Tehrani to engage in considering any of them, and then asking the lawyers who made the application, those that are representing and advancing H&81's interests, asking them what might be suitable is quite extraordinary. Given the centrality of this witness inquiry, the importance of him as you accept, sir, the need for a highly rigorous process was required before reaching any decision. And we say with respect, sir, that hasn't happened, or certainly we're not aware that that has happened. There is one more aspect to Dr. Tehrani which raises additional concerns. And so I don't need to tell you, but the overriding duty of an expert is to the tribunal, to you, and not to the party instructing them. So Dr. Tehrani's independence is seriously compromised by her entrenched, ongoing professional relationships with UK police forces, which creates a clear risk, a perceived risk, in favour of protecting officers from scrutiny. I won't go through all the list of the police forces that she's been involved in, but she served as force psychologist for multiple forces, including Surrey Police, as already stated. Her practice, Noreen Tehrani Associates, part of the website appears to be still under construction, routinely contracts with police and emergency services for trauma support and assessments, including psychological screening for the Home Office's Child Abuse Image Database project, which is a contract valued at over £11,000. So I've gone over my time, and I finish with this. We submit that the ruling, A, failed to have any regard or give weight to the importance and centrality of H&81's evidence. B, failed to scrutinise and consider H&81's engagement with the inquiry prior to the recusal application, including what his lawyer said in the opening statement about whether his evidence was to be believed or not. C, it relies solely on the report of Dr. Tehrani, who we say lacks appropriate expertise and lacks independence, such that it could not and should not have been relied upon. So we submit, therefore, that the ruling of the 24th September should be reconsidered by you, and in doing so, you will come to the conclusion that H&81 should be required to give oral evidence. And if you come to that conclusion, sir, we would invite you to set a ground rules hearing, if needed, to ascertain the actual support that H&81 needs to give oral evidence. It's only when he gives that evidence that you can then decide whether it's meaningful engagement or not. And so we finish with what was said by Mr. Justice Jacobs, and so you'll be aware of it. This was in relation to the Manchester Arena inquiry, in relation to an application that was made for judicial review by Mr. Tagdy. I'll give the citation EWHC 2878 admin. He said this, quote, "The chairman, in deciding the nature of the measures to be put in place, has to balance various factors. Mr. Tagdy's health and personal position are clearly relevant factors, but the public interest in the public inquiry being open to the public and the interests of core participants, including bereaved families, are also very relevant." Applying that in this instance, sir, applying the above balancing exercise, whilst regard must of course be had to H81's health, we accept that there are some difficulties that he's experienced. The importance and centrality of him giving oral evidence is such that there had to be, in this case, and in you reaching the decision that you did, there has to be the evidence which must be cogent, reliable, and truly independent to permit him not to. That's a balancing exercise. We say that there was not and there is not, and accordingly the balance here very much falls in favour of the interests of our clients who have a direct interest in him giving oral evidence, and indeed the public in doing so. So, with regret, I've gone over my time, I apologise, but thank you for your consideration. Okay. So I think I have to move back, so would you excuse me?
Of course. I'm afraid I don't have a batting order, so no doubt it's been agreed beforehand, and I will listen to whoever is next.
So I understand I'm next on
Yes.
behalf of Dr. Neville Lawrence.
So it's Mr. Ifeanyi Odogwu who's going
Yes.
to join us by remotely.
Remotely, right.
Otherwise, people will be coming up in turn to this microphone at the front of the room.
Yes. Thank you. Now, I have no idea whether with the open room I need to look at the screen or elsewhere to appear to be facing Mr. Odogwu.
My understanding, sir, is that it's still the camera that is up here in the centre of the,
Right.
the room.
So can I confirm that you can hear and see me?
I can hear you and I can now see you. And if I look at the camera over there, it looks as though I'm looking at you, but my head is going to be turned while listening to you, and I will appear to be looking away from you, but in fact I'm looking at you.
Yes, I'm well familiar with those juggling mechanics. So I appear for Dr. Lawrence with Adam Straw, KC, instructed by Hodge, Jones and Allen solicitors. We handed up a short speaking note this morning,
Yes.
which I'll take you through, and I do apologise that this only reached you this morning, but hopefully
Not at all. I
It is
have it and
not
I have read it.
assistance. Thank you. At the outset, Dr. Lawrence supports the written and oral submissions made on behalf of Baroness Lawrence and the submissions of Peter Francis, which invite you to reconsider your decision not to call HN81. I will use the time in this hearing to supplement those submissions rather than repeat them. Dr. Lawrence invites you, sir, to firstly call HN81 to give oral evidence, if necessary, with proportionate special measures under the vulnerable witness policy. Second, if, even with those measures, it is decided that oral evidence would cause disproportionate harm, the chair, you, sir, should permit core participants to put written questions and require answers from HN81. Third, in any event, we invite you to instruct a second independent expert now to advise on the risks arising from each relevant measure in the special measures policy and require written questions. Turning first to why HN81's evidence must be tested. I'm grateful, sir, to your confirmation in response to submissions just now on behalf of Baroness Lawrence of your view of the centrality and significance of HN81's evidence. That is, we say, uncontroversial. In weighing any risk of calling him against the benefit of doing so, that centrality should carry substantial weight. The point is underscored by the conflicts within his own account and with the accounts of the other witnesses. And for the purpose of this hearing, sir, we've set out just 4 examples in paragraph 5 of our speaking notes. The first example is in relation to the targeting of the Lawrences. HN81 says any family material on the Lawrences was incidental to his reporting and to the public order tasking against the MFJ. However, the documents include material of direct tasking in relation to the family at a high level, which he, of course, denies. For example, documents suggest HN81 was directly tasked by the Commissioner to infiltrate the Lawrence family. Documents suggest that the Lawrences refused to have anything to do with the MFJ. HN81 himself recognized the MFJ and the Lawrences were separate. And indeed, the main link between the MFJ and the Lawrences was HN81 himself, i.e. there would not have been any significant link absent HN81's involvement. Those matters cannot be resolved, we say, simply on the papers. It must be put to HN81 and answered. 2, why did he report on the intrusive personal material? HN81 relies on an intrusion to report everything. That's his justification to explain why he has reported intrusive material on the Lawrences. However, his own account, which you can see at paragraph 127 and 163 of his witness statement, shows that even on his own evidence, he shows selectivity in what he elevates for reporting and what he omits. This again requires answers. Thirdly, in relation to his public order justification, it is suggested by HN81 that the private family information was important and it mattered because MFJ might exploit it. So there is no evidence that anything HN81 did in respect of the Lawrences prevented public disorder. In fact, to the contrary, as you know, sir, in relation to his activities outside the Macpherson inquiry. 4th, in relation to the spy in the camp issue, to quote the Ellison report, HN81 denies being a spy in a Lawrence family camp during Macpherson, and his lengthy statement serves to downplay his significance. However, internal materials record his product as of, quote, great value and being read at the highest levels, including the Commissioner. And these were matters so that we set out in our opening statements. That is a direct tension on significance and motive in relation to HN81's own evidence, and it should be tested. So moving on to the what we say is the second issue that should be borne in consideration with this application, and that's the vulnerable witness policy measures. The ruling records the June 2025 opinion that oral evidence would carry significant risk and that no arrangements would make it safe. Others have addressed the medical evidence. Indeed, you've heard some submissions before mine, and I do not repeat them. The ruling, however, with respect, sir, does not address the vulnerable witness policy, which was published, I understand, after Dr. Tarani's report. It does not appear, therefore, that Dr. Tarani identified what if any, harm would be caused if HN81 gave evidence with each policy measure, or if he responded to written questions. It is also difficult to reconcile disproportionate harm with the fact that HN81 has produced an exceptionally detailed written statement and has very recently considered and given instructions on a lengthy opening statement. The vulnerable witness policy avoids a false choice between no evidence at all and unsafe evidence. It allows for the live link from a secure location, screening, voice management, a support person, structured time limits, breaks, questions through counsel to the inquiry, all matters, sir, which you will be well familiar with. And if live attendance remains unsafe, the inquiry's own policy allows for a recorded format and written questions. And respectfully, sir, none of that has been addressed in the medical evidence or in the ruling. Finally, sir, if HN81 is still not called, despite these submissions, and if after a focused independent assessment and a measure and an evaluation of his evidence, you are not persuaded that HN81 cannot safely participate, then there must be clear consequences for the weight of his evidence. Where his untested account conflicts with contemporaneous documents or with witnesses who have given oral evidence, we will invite you, sir, to place little weight, if any, on his statement. We will set out detailed conflicts and inconsistencies in our closing submissions, but we invite you to make that finding. Unless I can assist you further, sir, those are my submissions.
Thank you very much indeed. I would invite you not to leave the hearing, because there may be things said with which I would wish to ask you, about which I would wish to ask you in due course.
Of course,
Thank
I'll
you.
remain. Thank you, sir.
Yes.
Good morning, sir. I'm Joan Dyke and I represent Dwayne Brooks, OBE. Mr. Brooks asks, firstly, that the inquiry obtains an independent psychiatric report on HN81 and any measures that could be taken to enable him to give evidence. Secondly, that the inquiry provides sufficient disclosure of material relied upon by the doctors who have reported on HN81 to CPs with an interest in his oral evidence to enable further submissions to be made. This would, of course, be subject to appropriate confidentiality arrangements. Mr. Brooks does not want himself to see any personal or confidential information, but considers that his lawyers should. We are only too aware that we make these submissions today on the basis of insufficient disclosure. Your ruling is dated 24 September 2025. It appears to Mr. Brooks that the decision was in fact made sometime earlier, as at a meeting between the inquiry legal team and lawyers representing the non-state core participants on the 13th of August, it was noted that HN81 did not appear on the list of UCOs who were called to give evidence. We raised this issue and requested to make submissions on behalf of Mr. Brooks. The inquiry on the 16th September acknowledged that, in recognition of the importance of HN81's oral evidence to Mr. Brooks, the excusal should have been communicated to him through us. In spite of the centrality of HN81's evidence to Mr. Brooks, no submissions were sought from him on the decision to excuse HN81 at any point prior to the making of the decision at some stage, and we don't know when, before 13th August, nor, sir, after the specific request to do so was made before your ruling on the 24th of September. This ruling was ultimately published without any reference to Mr. Brooks. While Mr. Brooks is grateful to be heard today, he considers that as a matter of fairness, he had a right to be heard on such an important decision to him prior to it being made. Mr. Brooks has been left in the difficult position of having to try to reverse a decision which has already been made. rather than being given the opportunity to contribute to the decision-making process in the first place. In the circumstances, it is difficult for Mr. Brooks to accept the evidence upon which your decision is based, without any opportunity to scrutinise it. You said today that you consider HN 81's evidence central, and we're grateful to hear that, sir. But it's important that we set out to you why it's particularly important to Mr. Brooks to hear from HN 81. Rajiv Menon KC, in his opening for Mr. Brooks, told you that Mr. Brooks had been waiting for years to hear how Mr. Hagan seeks to justify what he did. Mr. Menon told you that Mr. Brooks was furious at the decision to excuse HN 81. There is no other way to put it. Mr. Hagan will no longer be required to explain any of the following. Why did he spy and report on Mr. Brooks between 1998 and 2001 for 3 years? Was he ever tasked by a senior officer to spy and report on Mr. Brooks, and if so, why and by whom? Why did he report on personal matters concerning Mr. Brooks that had nothing to do with public order? Why did he report on Mr. Brooks' civil claim against the Met Police? Why did he patronisingly and wrongly suggest in an intelligence report that Mr. Brooks was incapable of making his own decisions and was being manipulated by Alex Oaladi of the Movement for Justice? To what extent was his reporting based on fabrication, exaggeration or gossip? Was there racist banter amongst SDS officers? Was there more overt racism by senior SDS managers? Did he ever witness HN 86 do or say anything that was racist? Important issues pertaining to racism arise from HN 81's written evidence, which Mr. Brooks wishes to explore in oral evidence. So you will know that exploring racism is something that frequently, and in this case, requires careful oral questioning. Nothing else would suffice. In particular, at paragraph 87 of HN 81's Rule 9 statement, he stated, I was briefly and peripherally involved in the Anti-Nazi League, but a slip of the tongue in referring to an individual as a slave driver made me realise that I had lost credibility in their eyes and would probably never sufficiently be trusted to obtain public order intelligence. Further, Mr. Brooks wishes to explore with HN 81 why the term coloured appears in reporting in relation to which he admits that paragraph 92 would likely to have come from him, but nevertheless states that, as opposed to knowing, he believes coloured is not a term he would have used. Mr. Brooks also wishes HN 81 to be asked about a report dated the 17th of September about the Movement for Justice, in which HN 81 asserts, among other things, that Alex Oaladi had been instrumental in persuading Mr. Brooks to bring a civil case against the Metropolitan Police. Mr. Brooks refutes the assumptions made by HN 81 and seeks to understand why the report of 17th September refers to him in that way. Without HN 81 giving oral evidence, Mr. Brooks will never fully understand why HN 81 wrote what he did in those documents. Nor, sir, of course, will the inquiry, which necessarily impacts adversely on meeting the terms of reference in this regard. So, turning to the evidence before the inquiry leading up to this decision, at the time of your supplementary minded note on 23rd October 2017, there was no suggestion that HN 81 might be unable to give oral evidence due to ill health. At the procedural hearing on 21st November 2017 on restriction orders, there was again no suggestion that HN 81 might be unable to give oral evidence due to ill health. The restriction was placed on HN 81's real name with the very purpose of protecting his mental health. And so I was pleased to note today that you mentioned that you had hoped at the time of that ruling that HN 81 would give evidence.
I make it clear, I anticipated that he would.
So I'm very grateful to hear that. By 15th May 2023, HN 81 was able to produce a 77-page Rule 9 statement. There was still no indication of mental ill health to the extent that it might impact on his ability to give oral evidence. It was not until the 14th of July 2025, this year, that HN 81 applied by letter to you in reliance on the report of Dr. Terani dated the 21st of June 2025, as stated at paragraph 1 of your ruling. We were not told what her qualifications are, but Mr. Khan's submissions must surely be of concern now to you. We do not know what documents or reports she or you had access to. If not all the medical records, then surely this is something, sir, you will wish to put right. It is unclear what materially changed between 15th February 2017, when Dr. Busutil, a psychiatrist, prepared a report on HN81's mental health, and Dr. Terani's report, save for that the T3P1 hearings were by June 2025 due to commence imminently. The timing of HN81's application ought to give rise to keen scrutiny of the report of Dr. Terani, and in particular the statement that no arrangements could be put in place which make his appearance at a hearing safe, as stated in paragraph 2. So it is a rare witness who relishes the thought of giving evidence at a public inquiry, and especially so when their conduct is likely to be criticised. Further, and although Mr. Brooks can accept that a person's mental state may fluctuate, it is less than clear that it is Dr. Terani's opinion that HN81 has suffered such a serious deterioration since February 2017, when Dr. Busutil reported, which was itself over 6 years before HN81 was able to prepare detailed written evidence for the purposes of the inquiry. At the very least, given the question marks that exist over the current state of the evidence and Dr. Terani's opinion, and taking into account the importance of HN81's oral evidence to Mr. Brooks and others, the inquiry should commission its own evidence from an independent psychiatrist into HN81's mental health and ability to give evidence, including whether any measures can be taken to enable him to safely give evidence, including along the lines set out to you in earlier submissions, sir. We suggest that this is a practical suggestion. Dr. Terani prepared a medical report as recently as the 21st of June 2025. There is a real possibility that a psychiatrist instructed by the inquiry would also be able to prepare a medical report. Such independence would be informative, and whether or not it agreed with Dr. Terani would be reassuring to Mr. Brooks and perhaps also to others and to the public. In conclusion, overall, Mr. Brooks has been left with a sense of unfairness in relation to the decision-making in respect of HN81 giving oral evidence. It is unconscionable to Mr. Brooks that those who have suffered and been spied upon remain willing and able to assist the inquiry, while only 8 of the 25 undercover officers in Tranche 3 are giving oral evidence in open hearings. All Mr. Brooks asks is that the inquiry appoints an independent psychiatrist and ensures that the evidence is properly scrutinised and allowed to be subjected to appropriate challenge by those directly affected by HN81's conduct before any final decision is taken in relation to him. That, sir, would be fair.
Thank you very much indeed.
So these submissions are made on behalf of Sukhdev and Tishreel, Karen Doyle and MWS. All have been directly impacted by the deployment of HN81, known under the cover name David Hagen. So I endorse but do not repeat the submissions that have been made already today on behalf of other core participants surveilled by HN81. In particular, the application made by Mr. Khan of King's Counsel on behalf of Baroness Lawrence, Suresh Grover and the monitoring group. Instead, I wish to briefly emphasise the particular importance of HN81's evidence to the core participants on behalf of whom I make these submissions, the important and disputed issues on which he must be challenged, and the need to take all possible steps to secure his attendance to give oral evidence. I turn first to Karen Doyle's particular interest in his evidence. As the inquiry is aware, HN81 infiltrated Movement for Justice, an anti-racist campaigning organisation of which Karen Doyle was a founding member for around 4 years. In that time, he produced extensive and deeply intrusive reporting on the group's activities and its members. Karen Doyle has been provided with approximately 36 intelligence reports, naming her specifically, the vast majority of which are based on the intelligence of HN81. Those reports include detailed descriptions of her legitimate political activities with the group, as well as bizarre personal details, such as her plans for the Christmas holidays. Karen Doyle challenges the accuracy of many of these reports, as well as claims made in HN81's witness evidence to this inquiry, including his characterisation of the group and MFJ's methods. She also provides important evidence of HN81's behaviour whilst undercover with the group. More generally, Karen Doyle strongly challenges the lack of a legitimate basis on which to target and infiltrate MFJ, and seeks to understand the true reasons for his decision to target the group. This includes the extent to which MFJ was used as a base from which the SDS could monitor anti-police sentiment in the years following the murder of Stephen Lawrence, and to provide the Met with a link to the numerous family justice campaigns that were building in response to highly publicised police failings in that time. These are all crucial issues, sir, falling within the inquiry's terms of reference and issues list, on which HN81 should be challenged in evidence. I turn then to the Reel family. Sukhdev and Tish Reel were subject to intrusive surveillance by HN81 at a time when they were grieving the death of their son and brother, Lukvinder, known as Ricky Reel. In this time, they were engaged in tireless efforts to secure an effective police investigation into his death. As you will have heard in the opening made on her behalf, sir, Sukhdev Reel has particular concerns relating to the apparent interest that HN81 took in her and in the family, and the specific revelation that he offered her a lift home following a meeting. She feels that HN81 posed as a supporter of her campaign and used the opportunity to be alone with her in the car to gain intelligence on her family, and their campaign for justice. It was a gross and unjustifiable misuse of power. This incident does not feature in HN81's reporting, and so it's not known how many other similar incidents of direct targeting of the Reel family took place, given the paucity of remaining evidence and the tendency of SDS officers to admit no more than they absolutely have to from those records that do remain. This is a crucial issue on which we submit HN1 should be questioned and his evidence tested. More fundamentally, Sukhdev and Tish Reel wish to understand the reasons for HN81's interest in their campaign and the direction he was receiving from SDS and special branch managers to collect intelligence on the family. An SDS briefing note produced in 1998 reads as follows, and I quote, "It's important to emphasise here the extent to which the Reel's case has potential to cause police embarrassment on the same scale as the Lawrence case. Certainly, so far as Mrs. Reel and the activists are concerned, there are glaringly similar racist overtones between the police handling of both investigations. Again, Windmill Tilter, HN81, will be ideally positioned to monitor important developments in the months ahead." The use by the Met of HN81's deployment to inappropriately monitor the Reel family campaign for reputational reasons is a crucial issue falling within the inquiry's terms of reference and issues list, in relation to which HN81's evidence must be tested. Turning then to MWS, HN81's evidence is also of paramount concern to MWS, who adds their name to and endorses the written submissions provided ahead of this hearing on behalf of Sukhdev and Tish Reel and Karen Doyle. MWS is a member of the Family Campaign for Justice for Michael Taki Menson, who died in February 1997 in horrific circumstances following a racist attack by a group of men who set him on fire. In a typed record of an interview with HN81 in 2013, he confirmed his involvement with the Campaign for Justice for Michael Menson. MWS has also been provided with a number of reports produced on the basis of HN81's intelligence, which describe the activities of the campaign as well as references to individual members. However, they suspect that his involvement went beyond that which is documented in the disclosure received to date. MWS also urges the inquiry to investigate the underlying political motivations for HN81's interest in the campaign and strongly challenges any suggestion that such surveillance represented collateral intrusion, rather than a cynical and targeted wish to obtain intelligence on another family campaign likely to cause embarrassment to the force. These issues, as well as the role of racism in his targeting decisions, are all important areas on which HN81 should be questioned by the inquiry. I welcome, sir, comments you've already made today that such matters will be explored in the later evidence of T3 managers, but would emphasise that HN81 is uniquely placed to address these issues and would submit that his evidence is essential to the inquiry's determinations on those points. With all of that in mind, I then turn to HN81's participation in proceedings. Like many other core participants, those we represent were extremely disappointed by the news received not long before the commencement of Tranche 3 hearings that HN81 would not be called to give evidence. We note, sir, that he was able to participate in other investigatory processes in which he addressed the events under consideration by this inquiry, including being interviewed for the independent review of Mark Ellison of King's Counsel, which was published in 2014, many years after HN81 was said to have received his PTSD diagnosis. Others have already pointed out that HN81 also provided a lengthy and detailed witness statement to this inquiry, in which he makes a number of disputed claims about core participants and the campaigns of which they were a part. In that context, the core participants on whom these submissions are made struggle to understand why HN81 cannot, in any circumstances, give evidence to this inquiry. They cannot help but wonder whether his decision not to give evidence is, in part, self-serving and in keeping with a long history of secrecy and defensiveness on the part of the Special Demonstration Squad, given the likely challenges that he faces to his account of events in evidence. The submissions made on behalf of Baroness Lawrence and Suresh Grover, as well as on behalf of other core participants today, which emphasise the need to carefully and closely scrutinise the medical evidence underpinning your rulings, sir, are endorsed, and I do not repeat them. However, we do wish to stress the need for the inquiry to consider all available steps which can be taken in order to enable HN81 to give crucial evidence on contested matters. Your ruling, sir, states at paragraph 3 that the inquiry explored with the designated lawyers possible steps which might be taken to permit HN81 to give oral evidence, for example by doing so privately, but received the unequivocal response that no such step could safely be taken. We endorse the suggestion that's already been made by others, that the inquiry should take steps to verify this position for itself, including through the instruction of an independent expert. Sir, in conclusion, the importance of HN81's evidence to the core participants that we represent and to this inquiry as a whole cannot be overstated. His evidence is of absolutely central importance to these core participants. He's the undercover officer who carried out intrusive surveillance of their campaigning activities and their personal lives. Many experienced severe traumatisation and re-traumatisation as a result. With that in mind, they call on the inquiry to take all possible steps to secure his attendance, to give evidence, and to account for his actions. So in light of the time that's been made available to me, I conclude my submissions there.
Thank you very much indeed.
Thank you.
Now, who succeeds Mr. Lewis? Please.
Thank you, sir. Am I on? Yes. As you know, sir, I represent the cooperating group of non-police
Yes.
state core participants. The group endorses the submissions that have already been made on behalf of various non-police state core participants, and so we do not repeat those submissions now. It's clearly not in dispute that HN81 is a critical witness for this inquiry, and indeed for many other non-police state core participants, and not just those represented today. So can I just make two short points? The first relates to HN81's historic medical records and whether these have been obtained and considered by the inquiry and the assessing doctors. And the second relates to intermediary assessments. So first, in relation to historic medical records. So as you are aware, the non-police state core participants remain concerned about the credibility and reliability of the medical reports that you took into account from Dr. Busuttil and in particular Dr. Tarani when you made your decision on the 24th of September 2025. And as you're aware, the non-police state core participants are of the opinion that these medical reports are self-serving and that Dr. Tarani in particular lacks the necessary independence and expertise. This is because we, and so you, sir, know that there is another and perhaps more significant reason why HN81 does not want to give evidence to this inquiry. And this has nothing to do with mental ill health, but rather because he feels he will not get a fair hearing. In other words, HN81 does not want to be yet further criticised in public for matters of central significance in this inquiry. HN81 wants at all costs to evade scrutiny. That this is the position is clear from a very careful reading of the Tranche 3 opening statement submitted by the designated lawyers. It makes clear that one of the reasons why HN81 feels he can't effectively participate in this inquiry is because of the, quote, systematic destruction of his trust and faith in such processes. Of note, sir, this reason for not participating by HN81 is offered as an alternative basis for not giving evidence separate to the issue of mental ill health. So the fact that there appears to be another motive for HN81 not wanting to give evidence to this inquiry should lead to the utmost scrutiny being applied to any medical evidence submitted on his behalf. It also means any decisions that are taken by you should be taken by reference to robust, independent medical evidence. Focusing briefly, if I may, on the scrutinising of the medical evidence. The group asks, can the inquiry clarify what steps were taken by the inquiry to ascertain whether Dr. Tarani and Dr. Busuttil based their medical opinions solely on the self-reporting of HN81 and how he presented during their assessments, or whether these doctors obtained some or all of HN81's medical and other records, including occupational health and human resources records held by the MPS before coming to their views. In any medical assessment, this would be normal and indeed best practice, and indeed the civil procedure rules require any expert to list the medical records and documents that they have considered as part of any assessment. The group therefore asks whether this part of the medical reports prepared by Dr. Tarani and Dr. Busuttil can be disclosed, even in gisted form, so there is at least clarity as to how these doctors have arrived at their medical opinions and what, if any, medical evidence they have actually considered in respect of HN81. As you will know, there is a precedent for this, as gisted medical evidence for EN31 was disclosed to impacted CPs before submissions were made and his decision was taken on the making of a restriction order over his real name. This is also important because, as you've heard, Dr. Tarani's report and her expertise is challenged, but also because HN81 says he was diagnosed with PTSD in 2003. But curiously, Dr. Tarani appears to be under the impression that HN81 was diagnosed in 2001, and we can see that reference from Dr. Tarani in 2001 in your ruling, sir. It's not currently clear where 2001 comes from, but again it does raise questions about the scrutiny Dr. Tarani has in fact given to HN81's medical records in coming to her view. It also raises concerns about what Dr. Tarani has in fact been told by HN81. Now, briefly on the issue of medical records, we just flagged the following documents by way of example. The first has been very recently disclosed. This is a witness statement from a psychiatrist called Ian Palmer. Ian Palmer explains that they were a psychiatrist employed by the special branch to work in the SDS assessing undercover officers, and that they took over from Mary Piper in 2003. HN81 is critical of the support he received from the MPS in respect of his mental health. However, Ian Palmer explains that he was a specialist dealing in trauma, and that between 2003 and 2008, he had biannual appointments with undercover officers lasting a minimum of 1 hour, possibly longer. He explains that if there was a need for sustained treatment, then he would refer to the GP with the undercover officer's consent. He includes HN81 as someone who he saw. HN81 says in his witness statement that he was seen by both Mary Piper and Ian Palmer, with Ian Palmer making clear that he was only making an assessment of HN81. We already have some redacted disclosure showing that Mary Piper assessed HN81 probably on a number of occasions. The group therefore question whether, when Ian Palmer and Mary Piper assessed HN81, they considered whether HN81 had PTSD or a related mental health condition, and whether any referral or recommendation for sustained treatment was made in respect of HN81. If such a diagnosis or referral was not made, this begs the question as to why not, given we understand that there was, at this point, according to HN81, a diagnosis of PTSD. This is also significant because PTSD is a treatable and manageable condition, and HN81 has managed to produce a significantly detailed witness statement. Surely Mary Piper and Ian Palmer's assessment of HN81's mental health over a number of sessions and spanning a number of years would be important for the inquiry to know about, as well as any assessing doctor, including Dr. Tarani, Dr. Buttersill. Ian Palmer says he's willing to disclose his notes and reports to the inquiry. Can the inquiry therefore confirm whether these records were obtained by the inquiry before the decision was taken on the 24th of September 2025 not to call HN81, and whether Dr. Buttersill and Dr. Tarani also considered Mary Piper and Ian Palmer's medical records in respect of HN81 before they gave their medical opinions? If they did not, then this must raise real concerns about the robustness and credibility of their medical opinions. The group finally note another document. This is MPS 0723120/2. These are notes from 2009 and relate to a meeting between HN81 and DS HN367 and redacted DS, which provides some detail on HN81's medical condition at that time. We know that HN81 disputes some of these notes, but this document references the involvement of human resources and occupational health with HN81 and notes HN367 saying that HN81 was offered help from psychologists who deal with undercover officers, but HN81 was, quote, very much nonplussed about this, stated he'd seen someone before but felt they couldn't do much for him. Again, the group query whether any of this underlying material about HN81's medical condition, as it was understood at the time, including any refusal of medical treatment by HN81, has been obtained from the Metropolitan Police Service and then considered by Dr. Tarani and Dr. Busuttil before they gave their medical opinions. So finally, I'm moving on now to a separate point, and this relates to the steps taken by the inquiry to explore other ways for HN81 to give his evidence. As has been said many times today, you have indicated in your ruling that you explored possible steps with the DL lawyers and received the unequivocal response that no steps could be taken. Mr. King's counsel has already raised the obvious concern here, which is that it appears to have been left to the DL lawyers to explore with HN81 whether he can give evidence as a vulnerable witness. The group therefore questioned whether, rather than relying on the DL lawyers, whether the inquiry has considered obtaining an intermediary assessment to consider whether HN81 would be able to engage with giving oral evidence if assisted by an intermediary. And again, you've heard Mr. King's counsel making submissions about how this works and has worked in his practice in his extensive experience. Obtaining an intermediary assessment is a measure that is included within the inquiry's vulnerable witness policy at paragraph 9A. I'm not going to read it out, but it is somebody who is appointed independently by the inquiry. As the inquiry knows, an intermediary will assess needs and put forward bespoke, tailored support mechanisms to ensure that a witness remains within what they call the window of tolerance, so that they can provide their best evidence. An intermediary instructed by the inquiry clearly could and would probably have expertise going well beyond that of Dr. Tarani. We also just note as an aside that the application that was made by the DL lawyers regarding HN81's not giving evidence was made on the 14th of July 2025, and of course this was before the vulnerable witness policy was published on the 24th of July 2025. So it would seem that certainly when the DL lawyers made their application, they would not have had in mind your policy on vulnerable witnesses. Clearly, it's not a matter for the DL lawyers as to whether or not an independent intermediary could and should be appointed by the inquiry. And just by way of example, sir, registered intermediaries have recently been used in the Northern Irish Muckamore Abbey Hospital inquiry, and there's lots of evidence available as to how that worked very successfully, and it did include providing support to a vulnerable witness giving oral evidence, and it is self-evident, but perhaps needs to be stated that clearly intermediaries are used for witnesses who are vulnerable by reason of their mental ill health. Finally, just to state then, the benefit of an intermediary assessment, we suggest, is that it would provide an independent assessment by an expert trained in facilitating the giving of evidence by HN81 and indeed all vulnerable witnesses. And so this is not a submission that's made, it's simply to support the submissions that have already been made, and obviously the primary submission is that you obtain your own independent psychiatric expert evidence. The intermediary assessment is in addition to that in relation to the actual giving of evidence. So those are my submissions, unless I can assist you further. Thank you.
Thank you very much indeed.
Chair, as you'll know, I appear on behalf of HN43, Peter Francis, led by Ms. Sikan KC. It will be clear already, Chair, from our written and oral openings to this phase of the inquiry that our client has very significant concerns about the decision to recuse HN81 from giving oral evidence. Mr. Francis has a specific and direct interest in HN81's evidence, albeit for reasons different to those of the other call participants from whom you've heard today. To list, Chair, but a few examples of that. HN81 has repeatedly contested Mr. Francis's account of his tasking in relation to the Lawrence family campaign. HN81 once more calling Mr. Francis a liar in his inquiry statement. And indeed what HN81 also says in response to the allegations against him concerning his direct surveillance of the Lawrence family and other family campaigns has obvious and intersecting significance for our client and his evidence on those matters. HN81 also casts various aspersions on Mr. Francis in his statement in respect of his conduct and his activities undercover, all of which Mr. Francis refutes. HN81 also fails to reference in his statement a key meeting that Mr. Francis says took place in January 1998 at the beginning of HN81's deployment into the MFJ to brief him on his former targets and their relationship to the Stephen Lawrence campaign. That Mr. Francis will not, as matters stand, be afforded an opportunity to challenge such evidence, either by way of counsel to the inquiry or his own counsel, is a matter, understandably, Chair, of profound concern to him. And as Chair has already been recognised today, HN81's evidence is also of critical and underpinning significance to the discharge of this inquiry's terms of reference and the issues before you, Chair, that you will be required to determine. Chair, we endorse all of the preceding submissions that have already been made on behalf of the other core participants here today, as to the need to reconsider the decision to recuse HN81 from giving oral evidence and to scrutinise carefully the underlying medical evidence provided, including by way of an avenue of obtaining independent expert evidence. We don't seek to repeat, Chair, what's already been said, save to highlight two discrete and headline points of particular concern to our client. First, Chair, we reinforce the invitation for you to scrutinise the particular question of how it was that HN81 was able to engage in various earlier evidential processes addressing the same issue now before this inquiry, in view of Dr. Tirani's position that he's presently unable to provide oral evidence before this inquiry in any form. Of particular concern, which we seek to reiterate, is how it is that HN81 was able to engage with the witness statement process back in 2023 to the extent of providing a very detailed statement which contains numerous allegations against our client and indeed others that are contested, which would have involved a close revisiting of those events in view of the indication he had a PTSD diagnosis since 2001, confirmed in a 2017 psychiatric report, indeed well before that witness statement process. In this context, Chair, it's difficult for us to understand how and on what basis Dr. Tirani concluded in June of this year that there was an 80 to 90% chance that HN81 would be unable to meaningfully engage with this inquiry. And this all provokes a fundamental and unanswered question for our client, which is what, if anything, has changed between the provision of HN81's detailed statement in 2023 and now, to the extent as to preclude him from providing oral evidence to this inquiry under any circumstances, in any form. If there has, Chair, been a material change and or deterioration in HN81's condition between then and now, has this, we ask, been squarely addressed by Dr. Tirani in her report? And what does she say is the difference, if any, in the adverse clinical impact between providing such a detailed Rule 9 statement and giving oral evidence to this inquiry with the appropriate safeguards and adjustments? The recusal ruling, Chair, is silent on this issue, and in the absence of disclosure of Dr. Tirani's report, even in gisted or redacted form, we and our client, most importantly, have no way of knowing if this important consideration was addressed, which bears, of course, directly on the question as to whether HN81 really is unable to provide oral evidence before this inquiry on the grounds of ill health. Second, Chair, and relatedly, we note the indication in your ruling, and indeed it's been turned to several times already today, that the inquiry did explore with the DL possible steps that may be taken to permit HN81 to give oral evidence, but received the unequivocal response that no such step could safely be taken. That, Chair, further to receiving the report of Dr. Tirani, the inquiry sought to explore that issue directly with HN81's legal representatives, would tend to suggest, on the face of the ruling, that the issue of whether and to what extent specific measures could facilitate HN81's attendance was not addressed at all or sufficiently in Dr. Tirani's original report. It would also appear, Chair, on the face of the recusal decision, that the inquiry only sought to clarify and canvass this issue with HN81's legal representatives, as opposed to seeking a further opinion from Dr. Tirani, or indeed to instruct its own expert to provide an informed medical view as to whether any specific adjustments or measures could increase that percentage chance of effective participation and mitigate the attendant risk of adverse impact to an extent reasonably safe to facilitate HN81 giving oral evidence. The inquiry, we say, cannot rely on the assurances from HN81's legal representatives alone as to the insufficiency of all alternative measures to facilitate HN81 giving evidence. And we support the contention, Chair, already advanced by other core participants you've heard from, that it does not appear the inquiry has taken the necessary steps to verify that position for themselves. It's a key issue which we say must be robustly and closely explored by the inquiry before a decision is taken to excuse a witness from participating in the evidence hearings in any form. The question, Chair, as to whether there are alternative or special measures that could assist HN81 in giving evidence should be a primary consideration in any expert medical report placed before yourself in this inquiry supporting a witness's non-attendance, and indeed without which the inquiry is unable to make an informed and a balanced decision on the evidence as to whether or not said witness is able to give evidence. It's entirely and properly open to you, Chair, to request an opinion from an independent expert psychiatrist to address the issue of special measures, along with the various other matters that have already been raised today. But we say, Chair, that the first step in that chain doesn't yet appear to have been taken, seeking clarification from the source itself, Dr. Tirani, on whether she considers specifically alternative possible measures, including but not limited to those set out in the inquiry's own vulnerable witness policy, may facilitate HN81 giving oral evidence, and if not, indeed why not? Chair, you'll appreciate that our hands are somewhat tied behind our back today, insofar as we haven't seen the underlying material supporting the application for HN81 to be excused from giving evidence, or indeed a gist thereof. It does remain unclear to us, though, on the face of the ruling, whether and the extent to which Dr. Tirani's report expressly addresses the key issues on which I've touched and others have too, and how these have been weighted for and accounted for in the all-important decision to recuse HN81. If these issues have been addressed, sir, we are simply to be told as such, in plain terms, in an expanded ruling, so as to ensure transparency, and that our client, and indeed other affected CPs, can better understand the decision-making informing the recusal of HN81. If, however, it's the case, as it appears to us, Chair, that these key issues have not been expressly and adequately considered by Dr. Tirani, we say it's incumbent on the inquiry to now take the necessary steps to obtain additional medical evidence addressing these issues and to reconsider the decision not to call HN81 on the basis of an updated, more informed evidential picture. Chair, unless I can assist you any further, I believe that addresses the position on behalf of HN43.
Thank you very much. I think that concludes the submissions that are being made today, does it not?
So it does, unless the DL want to say anything through Mr. Sanders.
I have a question, two questions for Mr. Sanders. Mr. Sanders, or rather three. If there is anything you want to say, you're entitled to do so, and I would invite you to do so, but I have two specific questions for you.
Yes, go ahead.
First, as you know, there is a closed addition to the open ruling, which I take it that you've read. I intend in the observations that I am going to make today to refer to the articles of the European Convention on Human Rights, under which I have taken into consideration. Is there any objection to that?
No, sir, no.
Thank you. Second is this. An issue has been raised today by Mr. Odogwu, foreshadowed by his written submissions, that the inquiry, if it doesn't require either further medical evidence or the need for HN81 to give oral evidence, should ask written questions based upon those no doubt submitted by core participants. That is not an issue that I have addressed up to now, and it's not one I've invited you to address. I don't at the moment see anything in the medical evidence that I have read which would prohibit that. If there's anything you want to say about that, please do so now.
Well, sir, I can only give a provisional answer.
Yes, of course.
It may or may not be possible. I know that there's a strong interest in HN81 for his own welfare and well-being,
Yes.
having certainty and finality about his excusal from the inquiry process. And what I can't say is the extent to which a further round of involvement or addressing written questions may or may not impact on that. But I mean, I understand that that's a slightly different question from the one that Dr. Tirani was addressing.
It is.
But I can't. I mean, it may or may not be a possible or appropriate. Just in answer to what Ms. Heaven was raising then, we did go back to Dr. Tirani with the inquiry's questions about,
Yes.
and then reported back her answer.
That I understood to be the position. That it isn't just his legal representatives expressing an opinion, but an opinion expressed by Dr. Tirani.
Absolutely, sir. And I don't know if I may just very briefly make some submissions.
Of course.
But I'm happy to do it after lunch. We're past 1 o'clock, so.
Well, I think everybody, rather than delay everybody, I would prefer to deal with the matter now.
Absolutely. Sorry, sir, I'm being asked to speak up, and I'm just recovering from a cold. We obviously went over a lot of this ground back in 2017, 2018, with submissions being made as to whether or not you have power to compel individuals to undergo medical examinations, to get your own independent expert evidence, and so on. And all of those questions were dealt with at that point. In my submission, you've made your decision on the basis of the evidence we've submitted, and there are no grounds for reversing that or reconsidering that. Everything that's been said today about the view of other core participants regarding the importance of HN81's evidence, I know you've already taken into account, and you've already said yourself that you consider him an important witness, and if he were well enough to give evidence, and if it was safe for him to do so, then that's what would be happening. But you've also seen the evidence, private evidence, to demonstrate that he's not well enough, and it's not safe for him to do that. Some points have been made about what might happen in criminal or civil proceedings. These aren't, of course, criminal or civil proceedings, and there's no basis for the inquiry requiring HN81 to attend a different expert. You've obviously had the opportunity to put questions back to Dr. Tirani and so on. And I'd also submit that there's no basis for disclosing or sharing his private mental health information with other core participants and witnesses. There's no basis for saying that this is part of a pattern of individuals seeking to be excused on the basis of mental health grounds. The concerns about HN81 have been present since the start of this inquiry, and they're very real and very serious concerns. I understand that obviously everyone addressing you today doesn't know the underlying position, but I would submit, sir, that it's important for you, in giving your ruling, to address and respond to some of the rhetoric that there has been. There's headlines in a national newspaper today saying, excuse me, HN81 should be facing the full glare of public scrutiny, and that he needs to be confronted, use of cowardly, shameful, disgraceful. This is a human being who is very, very unwell. These are inquisitorial proceedings, and in my submission, it's important that your ruling addresses that and makes clear that he is not a coward or a disgrace or has anything to be ashamed of. Just very unfortunately, he is not well. Thank you, sir.
Thank you. I am invited by a number of core participants, led by Mr. Khan, King's Counsel for Baroness Lawrence, to revisit a ruling that I made on the 24th of September 2025, to the effect that HN81 will not be required to give oral evidence to the inquiry. That ruling was not challenged within the normal statutory time limit of 2 weeks. What I am being invited to do is to revisit it. The first point raised is that the medical evidence upon which the ruling was based, that's to say the report of Dr. Tehrani, may not be sufficient to support it and should be supplemented by further medical evidence. Mr. Khan with appropriate reservation submitted that Dr. Tehrani might not be adequately qualified to express the opinion that she has, and might, by reason of the fact that she has advised and provided psychiatric services for police forces, not be a truly independent expert able to express an opinion upon which I, as chairman of an inquiry, can properly rely. There is no doubt about the law which applies to reliance on expert medical evidence. It was set out with complete clarity in the General Medical Council and Hyatt, 2018 EWCA Civ 2796 at paragraph 38. It is true that the subject of that appeal was a decision that an individual had not demonstrated that he was unable to participate in proceedings rather than to give evidence in them, but the principle is identical. It is identified in paragraph 38 of the ruling, which cites the judgment of Mr. Justice Norris in Levy and Carr Ellis. I quote from the relevant part. Having said that the evidence required was far short of that needed to demonstrate that a party was unable to attend a hearing and participate in a trial, the ruling goes on to state, quote, such evidence should identify the medical attendant and give details of his familiarity with the party's medical condition, detailing all recent consultations, should identify with particularity what the patient's medical condition is and features of that condition which, in the medical attendant's opinion, prevent participation in the trial process, should provide a reasoned prognosis and should give the court some confidence that what is being expressed is an independent opinion after a proper examination. It is being tendered as expert evidence. The court can then consider what weight to attach to the opinion and what arrangements might be made, short of an adjournment, to accommodate a party's difficulties. No judge is bound to accept expert evidence. Even a proper medical report falls to be considered simply as part of the material as a whole, including the previous conduct of the case. The letter on which the appellant relies is wholly inadequate. Close quote. This is not, of course, a court case. It is an inquiry, but similar reasoning applies here. The first and very important question is whether or not I have satisfied myself that the opinion of Dr. Tehrani is that of someone who is expert in the field and is her own independent opinion. Her report details her experience, expertise and practice over many years and contains a conventional statement of truth, which I unhesitatingly accept. Dr. Tehrani was competent to express the opinions that she did, and they are her own opinions expressed in the knowledge that they will be relied upon by an independent chairman of a public inquiry. Mr. Khan, King's Counsel, supported by all other submissions, suggests that I should direct that a further medical opinion is obtained by a different expert instructed by the inquiry. I assume, for the purpose of dealing with this submission, that I have the power to do that. Were this anything other than a mental health problem, I would consider carefully whether or not to exercise that power. I do have in mind that Dr. Tehrani has expressed her opinion about HN81's mental health and functioning. In making a decision about whether or not to take further steps to obtain medical evidence, just as whether or not to compel him to give oral evidence, I must have regard to Articles 8 and 2 of the European Convention of Human Rights. This is not a case in which, as in the particular case of Dr. Hyatt, I am concerned with a physical condition where the obtaining of medical evidence about it would not put the individual concerned at risk of any, let alone any serious deterioration in the condition. I am faced here with the possibility that were I to order HN81 to submit to a further medical examination, the purpose of which would be to ascertain whether or not he was able to give oral evidence to the inquiry, I would be putting at risk the very things that have been identified, which, in my judgment then and now, prevent him from doing so. Given the nature of the risks to his mental health and well-being, and the articles of the Convention to which I have referred, that is not a risk which I am prepared to take. I make those decisions in the knowledge that I have said and continue to believe that the evidence of HN81 is of vital importance to the inquiry. Until I received the application on 14th July 2025, I had anticipated that HN 81 would give oral evidence to permit those aspects of his evidence which disagrees with that of other witnesses and which makes unfavourable observation about some of the core participants upon whom he was reporting. To permit me to assess its truth and reliability. Hence the avenues that I explored through his legal representatives, which were unequivocally rebutted by Dr. Tehrani. I can take no further step which will put HN 81's mental health and well-being at risk by reopening the possibility that he may be required to give oral evidence. A suggestion was made by Mr. Odogwu and supported by others that the inquiry should investigate the possibility of putting questions, written questions, to HN 81 and inviting his response, his written response. This is not something upon which I have ruled hitherto. It is an open question. Given that he has provided a detailed written witness statement, albeit 2 years ago, and given that I have no medical evidence which would indicate that it is unsafe to adopt that course, I invite those who represent him to consider and to respond within 14 days to the suggestion made that written questions be devised and put to him through them for him to provide written answers. "14 days should provide sufficient time in which to obtain his instructions and, if it be the case, any medical evidence relevant to the issue." That concludes this ruling. And today's hearing, with apologies for delaying everybody's lunch.